Hello and welcome to TaxSnax. My name is Rebecca Sheldon. I am a barrister at Old Square Tax Chambers, and today I'm going to be discussing the FTT process, taking you right from notifying an appeal up until looking at what you can expect to happen at the hearing. So starting then with notifying an appeal. So once you're at the point of notifying your appeal, so for example, you have received a closure notice, if it's a direct tax like income tax or CGT, you appeal to HMRC within 30 days and in writing. And that's section 31A of the TMA 1970. Now, the notice must specify the grounds of appeal, so you can't simply say I am appealing, and you then notify the appeal to the FTT. So you notify them that it's happened. This process can be delayed by the appellant requesting or HMRC offering and the appellant accepting a review. Now, in my experience, HMRC very rarely change their minds during the review process. I mean, I have seen it happen once, but beyond that, no, not really. However, it can be helpful to request a review where you are sure that HMRC has missed some of the facts, such that a review by a second officer may result in a different conclusion. And in fact, that's what happened in the one circumstance where it actually did result in a changed mind, or where you want more time for the process to run before you notify the appeal to the FTT. Now, for indirect taxes such as VAT, this is the other way around. So you appeal to the FTT rather than HMRC, and then you notify HMRC that you have appealed within the requisite 30 days. And that's governed by section 83G of TMA 1970. So what do we do if we have accidentally missed our deadline? So section 49 TMA 1970 allows for a late appeal where a notice of appeal has been sent to HMRC in writing, there is a reasonable excuse, and it is made without unreasonable delay after the reasonable excuse has ceased. So what this means is that you have a good reason for missing the deadline. So for example, you were sick, and once you stopped being sick, you made the appeal as soon as possible. You didn't sort of wait a few months and then do it. Now, where HMRC don't agree that the conditions in section 49 TMA are met, all is not lost because you can still make a late appeal to the FTT under something called the Martland test. Now, this is a case which has set out 3 conditions for the tax tribunals to look at late appeals. And this involves considering the length of the delay, the reason for the delay, and all the circumstances of the case. Now, the length of the delay will be serious and significant where it is more than 3 months long. Now, where the delay is longer than this, the importance of the reason for the delay is going to be heightened. So if it has been categorized as both serious and significant, the better the reason, the better your chance. Now, simply forgetting about a deadline is unlikely to be considered as good a reason as, for example, this is quite extreme, example, a taxpayer being in a coma. Obviously, as you might expect. And then finally, all the circumstances of the case are going to be considered. And this includes things such as the prejudice to either party, the actions of either party in contributing to the delay, and the broad prospects of success. Now, this latter issue, the prospects of success, is not considered in detail, as a late appeal application is not to be used as a mini trial. However, whether the prospects are obviously good or obviously bad, this is going to be a factor weighing into whether permission is going to be granted. Now, before you go ahead and do all of this, it's really sensible to seek advice from counsel on whether a late appeal application is likely to succeed, because there is a significant amount of case law in this area, which it might be useful to refer to. Moving then to the FTT's jurisdiction. So the FTT has the jurisdiction to decide both the law and the application of facts to the law regarding tax disputes between taxpayers and HMRC. Now, HMRC will often argue that the FTT has no judicial review function and as such is unable to hear public law arguments. So far as it goes, this is correct, and in order to bring public law arguments, it is often necessary to bring a JR in the High Court. Now, this can be challenging time-wise, as there's a deadline to bring JR proceedings as soon as possible, and in any event within 3 months. However, it is also a remedy of last resort, and therefore can only be brought when options like the FTT are exhausted, which, is sort of confusing. So the trick here is to bring a JR and then apply for it to be stayed whilst the FTT proceedings are ongoing. Otherwise, you will run out of time to bring your JR. So moving then back to the FTT's jurisdiction. So it is possible for the FTT in certain circumstances, very specific circumstances, to hear public law arguments within their general supervisory jurisdiction. And the sorts of arguments you might want to look at are whether, for example, a legitimate expectation has arisen. So the courts have, over a really confusing series of case law, in particular Knorr and then Zeman, held that they can do this where the tax legislation does not exclude such an interpretation. For example, where the legislation sets out that HMRC may do something, and that therefore there is, an exercise of discretion which the FTT can look at. This is a really highly technical area, and advice should again be taken from counsel on when a JR is necessary or when a public law argument can in fact be made in the FTT. So then, steps to a hearing. Now, the first step after the appeal is with the FTT is that the case will be allocated as either a default paper case, a standard case, or a complex case. Now, most appeals, as you might imagine, fall into the standard category, and it's this that I'm going to focus on mainly. However, it is important to briefly note the different cost consequences between the standard and complex case track, because this can confuse taxpayers. So on the standard track, each party covers their own costs, regardless of who wins, and that's unless there's either a wasted cost order or a cost order issued as a result of unreasonably bringing, defending, or conducting the proceedings. And in contrast, on the complex case category, unless the appellant opts out within 28 days of being given notice that their case has been allocated to the complex track, the cost regime will apply. And this means normally that the costs will follow the event, i.e. the loser will pay the costs of the winner. And that's really important to bear in mind, particularly if cost is a factor in you deciding whether or not to proceed. So moving then to look at the directions from the FTT on the standard track, the FTT will usually direct HMRC to produce their statement of case within 60 days. Now, the statement of case summarises HMRC's arguments, the relevant legislation and case law, as well as provides the appellant with HMRC's understanding of what their position is. Now, one thing to look out for in the SOC in a relevant case is whether HMRC has actively pled fraud, because there are only limited circumstances and ways in which they can do so later. After the statement of case, the parties will usually be directed to provide and exchange the documents on which they intend to rely. And this is a crucial stage for the appellant, who will usually have the burden of proof. So it is vital that proper thought and care goes into obtaining evidence. In factual appeals, for example, those involving domicile queries or ascertaining whether there have been exceptional circumstances under the statutory residence test, this can very much be the difference between winning and losing a case. It is also useful to note here that the usual direction in other court systems that the parties disclose documents which are adverse to their case does not usually get ordered. There are some exceptions where you're looking at, for example, a Kittle case, which is a very particular type of VAT case, but usually you are only directed to provide the documents you intend to rely on. Now, after this, directions will be issued for witness statements, and there are two broad types. So there's a factual witness statement, which records a person's understanding of the facts, and then expert witness statements, which give an expert opinion on an area which the judge is unable to take judicial notice of. So, for example, the technical way in which certain IP operates. Now, for factual witness statements for HMRC, this is usually going to consist of a witness statement from the officer explaining the process behind the assessment and the reasons for why an assessment has been made. And for the appellant, this will usually include a witness statement from the taxpayer as well as supporting witness statements from others. Now, I can understand why this happens, and it does happen a lot, but this is not an opportunity to complain about HMRC or to make legal submissions. It is an opportunity for the taxpayer and their supporting parties to explain what has happened in their own words and why. It is actually quite detrimental to spend a lot of the witness statement talking about the various ways in which you are upset with HMRC. Now, for an expert witness statement, special permission must be applied for explaining why the report is necessary, and the FTT can direct that a joint expert opinion is sought. Now, further, and this is one thing that people don't often realise, so it's important to remember that the expert witness's duty is to the court. It is not to the person who is paying to obtain the report. And so just because you have paid someone to provide an expert report, it doesn't mean that they're necessarily going to support your case. Now, the FTT will then direct for listing information to be provided. So this includes who's going to attend for each party, who's going to be speaking, when each party is free to attend the hearing, and how long it's anticipated a hearing will last. So the final step before we get on to what happens at the hearing is the creation of the hearing bundle. So this contains all the documents of both parties, the authorities bundle, and the skeleton arguments. Now, skeleton arguments contain a concise summary of each party's submissions on the law, as well as a summary of the key facts, legislation, and case law. And as the appellant usually has the burden of proof to the civil standard of the balance of probabilities, their skeleton argument is normally exchanged first, roughly 3 weeks before the hearing is due to begin. And HMRC will normally be directed to exchange theirs 7 days later. So we're now up to what happens at the hearing. And when you get there, the very first thing to do during a hearing is to check that the judge has sight of all the bundles and skeleton arguments, because they can occasionally get lost. And obviously you want the judge to be able to see the evidence that you've put in. Now, in the FTT, you refer to a judge simply as judge, whether they're a man or a woman. During the hearing itself, if the appellant, as usual, has the burden of proof, they will go first and open the case to the judge. And this, in effect, just explains what the case is about and what the parties' positions are, and maybe a brief look at sort of the legislation and case law. Now, after that, the appellant will call its witnesses, and each witness will be asked to look at their statement, confirm that it is theirs and that it's accurate, and then asked if they have anything left to add or change. Now, if any further information is needed, the barrister will ask the witness open questions in a process called examination in chief. An open question usually starts with who, what, where, why, or when, and it's designed so as not to lead a witness to an answer, because that prevents the other side from being able to say, well, you shouldn't really take the witness's evidence into account because really they're just saying what their barrister wanted them to say. Now, after this is finished, the barrister of HMRC will be allowed to cross-examine the appellant's witness, and this involves using closed questions, so the opposite. So it's right, isn't it, that this happened, because this is designed to lead a witness to a particular answer. The key, really, when being cross-examined is to be entirely honest, to take your time answering the questions, and to make sure that you are answering the question that you've been asked, not the question that you wish you had been asked, a bit like an exam. Answer what you have been asked, and don't try to be over helpful, but equally do answer what you have been asked. Now, once then the judge has asked any questions of the appellant's witnesses, the process will reverse, and HMRC will call their witness, and the appellant's barrister will be allowed to cross-examine them. So basically the exact same process, but in reverse. And once again, the judge will ask any questions they have of HMRC's witness. We then get to the closing submissions. So the appellant's barrister will go first if they've had the burden. So they get to make their submissions on the law, having heard the evidence of both parties and what they say the outcome should therefore be. Now, sometimes the judge will interject and ask questions. Sometimes they will just sit there and listen. It really depends on the judge, and you shouldn't really read too much into it either way. And after that, HMRC will then make their submissions on the law. Finally, the appellant's barrister will be allowed to reply, but this is not a second chance to make submissions from scratch. What this is it's supposed to allow the appellant to respond to any new points that have been raised by HMRC's barrister in their closing submissions. So it shouldn't take very long at all. After that, the judge will usually say that they want to reserve judgment rather than giving it there and then. So you won't find out on the day, usually in an FTT case, what the conclusion is. And they will provide usually a written judgment. Now, in my experience, I've had this be as quick as a week after I've been in court, and I've also had it be as long as 6 months later. So how long is a piece of string as to when you're going to get your judgment? But then it is a waiting game. and you wait to see how the judge has come back. And then if it's gone for you, great, and you wait to see if HMRC is going to appeal. And if it is gone against you, you then have some time limits to decide whether you want to appeal. That's not for this particular talk, that is for the next talk. So I will leave that to the next one. Thank you so much for listening.